This part is extremely important in a certain perspective that I will indicate, which is one of the arguments which I propose to raise. Now, who is the head of the state? It says the head of the state shall be designated as the governor. There was a change earlier. It was first Maharaja, then Sadr Riyasat, now it is governor. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through subordinate to him in accordance with this constitution. Nothing in this section shall be deemed to transfer to the governor any functions conferred by any existing law on any other authority, or prevent the state legislature from conferring by law functions on any authority subordinate to the governor. Appointment of governor. The governor shall be appointed by the president of warrant under his hand and seal, provided that the person holding office as Sadr Riyasat immediately before the commencement of the Constitution Jammu and Kashmir 6th Amendment Act shall on such commencement be the governor and shall, subject to other provisions of this Constitution, continue to hold office as governor until the remaining period of his term. The governor shall hold office during the pleasure of the president. The governor may, by writing under his hand, direct his president to resign his office. Subject to foregoing provisions, the governor shall hold office for a term of 5 years from the date on which he enters upon his office, provided that he shall, notwithstanding the expiry of the term, continue to hold office until his successors enters upon reference. Qualification: no person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 30 years. Conditions of office: the governor shall be a member of either of the office. Governor, he shall be deemed to have vacated his seat in the house on the date on which he enters upon. The governor shall not hold any office of profit. The governor shall not be entitled to such emoluments. Now, what is important is in this, the oath which he is required to take. That is section 31. The governor and every person discharging the functions of the governor shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of the High Court, or in his absence, the senior-most judge of that court available, on oath or affirmation the following form. That is to say, I so and so, that I will faithfully execute the office of governor or discharge the function of the governor of Jammu and Kashmir, and will, to the best of my ability, preserve, protect, and defend the Constitution and the law, and that I will devote myself to the service and well-being of the people of the state. And the governor stabbed the people of the state in the back. He committed serious breach of the oath by making a recommendation to abrogate Article 370, which he could not do. Had he been a sitting governor, perhaps impeachment motion could have been moved against him. He is to uphold the Constitution of Jammu and Kashmir, and he destroys it by his recommendation to the president, that you apply all the provisions of the Constitution of India to us, which even the Constituent Assembly did not do. He requests the President of India, you change the Constituent Assembly to Legislative Assembly, and the President of India is pleased to accept the recommendations of the governor when he acts in breach of the oath of the Constitution of Jammu and Kashmir, which is serious constitutional misconduct committed by the governor. And in this particular case, there is no evidence produced. Nothing is stated in the counter affidavit. When was the recommendation made? Who?
We need to labor the point further. Now we look at what was the position on the eve of the abrogation, which is 4th of August 19. Because your argument will be that even as on the 4th of August 2019, notwithstanding all the subsequent application which took place, there was still a core left with the Jammu and Kashmir State Legislative Assembly. So you can give us, like we have now done for 1954, some 3 or 4 examples, and you can put the rest on a piece of paper, just sort of putting it all together.
I can put it entry-wise, this entry, this entry, this something. That I can do.
But just confine it to the key areas, because that will buttress your point, isn't it?
That's the problem, which is the key area.
No, I mean,
I have
where the rub lies.
States being together. I mean, unified state is a key area. Who is a permanent resident is a key area.
Right.
I mean, these are the key areas.
So can you just summarize them after lunch for us? Which are the key areas? So that then we can move on to the rest of the argument.
I'll do that. So that
got the drift of the argument. We just thought that we should have some illustrations, which are the key illustrations that will sort of drive the point home.
So unless your lordship were writing the judgment, would be very specific. Look here, the state still enjoyed its autonomy in respect of A, B, C, D. That's being specific.
Right.
Second would be also would say they did have some.
What has
What
been
was
taken,
that, sir?
what has been taken away by the child under the provisions? Which are you on the?
What has been taken away, what was left with us? What would be general statement making, sir? I had, as I tried to give example, 100 grams with me, they took 70, 30 still with me. But what was that 70, what was that 30? I thought that I would deal with it in more specific terms. This is taken and this is with it, rather than being general about it. That's what I was trying to.
Sir, the only thing is time in all this becomes a little constraint. Now, yes, there was a position in 1954. We've understood your position in 1954. That at various times to time, something may have been chipped away.
Yes,
Is there, when and how is not before us. Because that's a post facto situation,
yeah, very true, very,
as you also are.
very.
Now, something happened which is under challenge. So
Yes.
a pre-challenge position for us to appreciate what was the pre-challenge situation which has been deprived in the result of what you have challenged.
Yes, yes.
So let me finish.
With your lordships, I'm with your lordships.
We have understood your broader arguments on consultation and concurrence. Now we just would like to know what was the residuum, the residuum which was left on the eve of the
What
abrogation.
was left of constitutional autonomy? It was in simple language.
As you said,
What is left of constitutional autonomy?
there was something left. What is that something is the only thing we are wanting to know.
All right, we'll just look at it after lunch. And just, yeah, one thing, we'll take a look.
Part 6 was not applied.
Go ahead. Mr. Shah, now what is a rough time estimate for you to complete?
I need to still argue, so I have some problems I need to argue.
About, should we give you another hour or so? Can we wrap up in an hour so that then
No,
the
sir,
next
it will be
person?
more than that. It will be more than that. I would repair it might spill over even because I have some more to say.
I know all of you have some things to argue. Our constraint is also at some stage things have to end.
Give me that little
With
freedom.
all your ability, I'm
And
sure
the-
you can, with all your ability, you can.
Important case for us.
Of course, we understand.
Important
That's why
case
we are
for
giving
the
so
state.
much of time.
And
Of course,
there
Mr.
is
Shah,
some
no
freedom
doubt about it.
given.
Mr. Shah, can we do this? Can we suggest this after lunch? You can give us broadly the themes on which you are going to argue. Just formulate the themes so that we also have a clear picture that how you are now going to unfold the rest of the argument. Just give us the 3 or 4 themes